seated, please. We have two cases on the docket, and as counsel apparently has anticipated, we'll take them in the order in which they appear. First case, Wal-Mart versus Thompson.
I want to cover up the time. Thank you, Your Honor. Your Honor, my name is Jimmy Earl, and I represent Wal-Mart, the appellants in this matter. We are here today requesting you to reverse the order of the judge of compensation claims entered in this matter on April the 26th that awarded two benefits. Those benefits were, in sequential order, temporary partial disability benefits for a 17-day or 17-week period of time from April 16th to the date of stipulated maximum medical improvement on August the 23rd of 2007. More aptly thereafter, we're requesting a reversal of the order, finding the claimant to be permanently and totally disabled, effective April 23rd, 2007. The appellant does not, in fact, take issue with the findings of fact of the judge, especially in the first 8 pages of the order. In fact, we embrace those as accurate findings of fact. The claimant here ends a 52-year-old female, 2 years of textile training after a high school education, industrial history of cook, cashier, night manager at a restaurant, waitress, had an admitted compensable accident. The judge very aptly describes in his
Counsel,
order.
with all due respect, why is any of that relevant to your issue on appeal? Why is any of that relevant to your issue?
Well, it's all issue because the concept of the injury and the extent and nature of the disability, i.e. the ability to earn from the injury itself, is material, especially the findings as made by the judge in quantifying and identifying the injuries, which I think he did very accurately, as I pointed out in the first 8 pages of his order, when he referred to the findings as being a paucity of medical findings. And
let's say we grant you that.
Yes, Your Honor.
Paucity of medical, rather than findings, paucity of medical evidence, et cetera, et cetera. Where does that get you in light of the current version of 440.15.1b?
Both in terms of 440.15.1b and 440.15.4, the obligation, I believe, still exists, Your Honor, in the absence of medical evidence to the contrary, to place the burden of proof on the claimant. The burden of proof can be satisfied by either medical excusing a good faith job search or alternatively by the claimant having conducted an extensive good faith.
Did you make that argument? Did anyone make that argument before the judge of compensation claims?
Yes, Your Honor, we did, and it was preserved in our trial brief and at the trial level. The judge very clearly pointed out that upon obtaining maximum medical improvement, the claimant returned to work for the employer and continued to work for the employer for 6 months following the accident and then walked off the job. That's the judge's finding, that she walked off the job. The reason as stated was that she was being harassed and she felt like she was being harassed. And
Counsel, let me ask you that question again. Are you telling me that you argued before the judge of compensation claims that there was an absence of showing of a work search in this case?
I'm sorry,
Are you telling me and the rest of the court
Yes, Your Honor.
that you presented, or whoever tried this case, presented an argument to the judge of compensation claims that the lack of a work search barred this claim?
Yes, Your Honor, we did. It was preserved in our trial brief and in our closing argument with the judge of compensation claims, and was the preserved testimony that was obtained 15 days prior to the final hearing, when it was confirmed and the judge adopted the finding that she made absolutely no job search for the 1 year period of time after she left the...
Counsel, excuse me,
yes,
but let's assume she didn't do a job search,
yes,
although it seemed to me there was some evidence from her that she did do a job search. Let's assume for purposes of argument she didn't. Isn't there competent substantial evidence in the form of the claimant's vocational expert to the effect that there was no job that she was capable of doing? What would the point have been of doing a job search if she was incapable of doing any job that was available?
I would agree with you, Your Honor. If she was physically incapable of doing a job, then there certainly should be.
Isn't that what the vocational expert testified?
No, Your Honor. The
It's
vocational expert testified that she did not feel that she could find a job for her in the 50-mile radius of her residence. The vocational expert, of course, did not see the claimant until 6 days prior to the evidentiary final hearing, after the claimant's deposition had already been taken.
I thought Panaccio, and this may be a slight difference, but I thought Panaccio testified that she was not employable within a 50-mile radius of her residence.
She
It's
did
slightly
not
different than
conduct
saying-
a job or a.
It's not my question.
Yes.
I mean, the problem, obviously, here, the elephant in the room is this new statute that we've got. It
Yes,
took
Your
away the requirement of a catastrophic injury and restored the pre-1994 vocational test to permanent total disability. And you remember, and I certainly remember when I came to this court looking at records, and I see Mr. McCabe out there, and y'all are all comp lawyers, 5% chiropractic, lengthy job search, hey, PTD. Looks like we're back.
I agree with you, Your Honor. 30 years later, we've gone through the 1993 amendment up to the amendment in 2000, and then the more recent amendment in 2003. I'm sorry, in 1990 we had the little blip in there with the 100. And Your Honor addressed that rather thoroughly in the Loggins case, which also involved, as fate would have it, Wal-Mart, and is pressed upon the importance there of a bona fide good faith job search and exhaustion of that job search in the absence of some medical evidence that would excuse it. There is.
Wait. I thought you just agreed with me that if the vocational expert testifies that there is no job available for a claimant, that excuses the need for a job search, assuming the JCC accepts that testimony.
Your Honor, if the JCC accepts that testimony, then you would be correct.
Doesn't the JCC accept that testimony here?
I can't tell that he does.
Well, there's no other basis for a TPD determination, is there? Without the vocational expert's testimony, you don't get the TPD, do you?
Well, the TPD comes long before the vocational expert even becomes involved. The appellees have cited the Arnold case as basis for the TP argument, and this court addressed several things that came up in the new law. One, was there a misconduct that would constitute a sanction barring eligibility for ongoing payment of TPD? There was not there. Was there a voluntary walking away from employment during the period of time that she was collecting temporary partial? There was not there. The court here held in that Arnold case that the judge urged, sent it back to him for a reconsideration because there the claimant had made a bona fide job search for a 6-month period of time.
Well, okay. The JCC found that this woman was permanently, totally disabled. Did it not?
He made the finding it was almost incomprehensible that she was, and then went on to, yes, make that quantum leap.
He ordered her PTD benefit.
Yes, he did, Your Honor.
Without the testimony of the vocational expert, it would not have been possible to do that, would it?
Absolutely, Your Honor.
So
Everything else
the
was...
JCC must have accepted that testimony.
Your Honor, that brings us right back to the very heart of the issue, and you're absolutely correct. If that is, quote, competent and substantial evidence, then I'm home. I might as well go away.
Well, then why
Judge
isn't it
Leandra Shaw addressed this rather, succinctly in the Grant case, which we've cited in our brief, and thereafter it was brought up in the Cook case, which is cited in our brief. There was no way to rebut this rehab provider. You won't find a report.
You could have brought in another rehab provider who could have testified that there were jobs available.
When the deposition of the claimant was taken 15 days before, she didn't even know about a rehab provider.
But in fact, isn't it true that the Wal-Mart didn't even have a job available at the time for this?
Your Honor, we have no way of knowing.
Isn't that true?
I can't say that. She did not go back to the Wal-Mart for over a year after she walked out of the job. And then she went back sometime in the 8 days prior to the final hearing. Doesn't say that she applied for a job. She asked a manager if there was any light work. That's all she did.
Isn't there evidence, I phrased my question
Yes, Your Honor.
Isn't there evidence, at least in this record, that Wal-Mart did not have a job available for her that she thought she could do?
No, Your Honor, there's not, except for her comment when she went back.
Counsel,
No, I'm not meaning.
am I mistaken that that's evidence? It may not be good evidence, but isn't that evidence?
We cannot say if there was job available if she never tried in over a year, Your Honor. She never went
She
back.
didn't go in and ask after she didn't.
No, Your
How
Honor,
about
she did not.
Pinocchio? Did she check with Wal-Mart to see if there was a job available?
Not at all. The judge specifically found that she made, and this is his terminology, absolutely no attempt at finding any work or getting any
I'm
employment.
talking about Jerry Pinocchio, the vocational counselor. She didn't check with Wal-Mart to see if the old job was available?
No, she did not do a labor market survey. She didn't talk with anybody. She didn't even have a report
Because
done.
she concluded that, in fact, this woman was unemployable, didn't she?
That was her conclusion, yes. Based
Why
upon-
isn't that sufficient, competent, substantial evidence?
For the same reasons as set forth in the W.T. Grant case and in the Cook case, Your Honor.
What are those reasons?
It's trial by gotcha. We're not going to have workers' comp turning
Did
into
you
a...
object on the basis that this evidence from the vocational expert was being offered too late in the game?
No?
Did you object to her testimony at all?
There was no objection to the admissibility of her testimony.
Well, then how is it a gotcha?
I'm sorry, Your Honor?
How is it trial by gotcha?
Because there was no voc rehab eval up to 15 days prior to the final hearing. We have a claimant with minimal impairment identified by the judge, no attempt at finding any type of work, who has walked off of a job as defined by the judge. And, you know, we can be legally smart and practically stupid and go out and try to defend everything in the world, but there was nothing on the record or going into the final hearing that would suggest anything other than that which we had.
And so when the vocational expert testified that, in fact, this woman was not employable in any job, you didn't object to that on the basis of unfair surprise, did you?
Her name was listed on the pretrial statement, Your Honor.
But you didn't object to that testimony on the basis of unfair surprise, did you?
No, Your Honor, I didn't. I did not. I thought it went to the weight that provided the testimony, and I've never run into a situation where you can object to the weight of a testimony and have that.
Let me ask you a question.
Yes, Your Honor.
Would you concede that there is evidence in this case of permanent impairment?
Your Honor, that was stipulated to at the time of the pretrial.
Would you concede that
in
there's
January,
evidence in the case that the permanent impairment is employment related?
Yes, Your Honor. We have
And would you
agreed to
concede that there's vocational evidence in the case that there's no job for which this woman is able or qualified within 50 miles?
We agree that there is such
However
testimony, but we believe it is legally insufficient for the same reasons as, you know, set forth in those decisions that are
But
cited
those
in our
decisions, Cook and Grant or whatever they are, those old IRC decisions, they seem to suggest that vocational testimony is not sufficient to support a claim of wage loss or wage diminishment. I don't think that's the law anymore.
Not all by itself, Your
You have to
Honor.
have all you need with it is the medical testimony of impairment, I would suggest.
Well, that's the way we're taking that quantum leap. If you have an impairment, if you have limitations, and you bring in a voc expert says a year and a half after you've walked off a job that you've worked on for 6 months and says she's unemployable, if that's competent, substantial evidence, then yes, you're right.
But I'm pretty sure that the claimant's bar didn't write this statute in 2003, just like I'm pretty sure they didn't write the provision in 1993 concerning catastrophic injury.
No, nor do they write it in...
You know, believe me, I don't think any of us that have been hearing comp cases for a while don't understand the frustration, but here's a statute that appears, and you can contradict me, it appears to suggest that if you have medical evidence of an impairment coupled with any vocational evidence of unemployability, that judge may find the claimant to be permanently, totally disabled.
I respectfully hope that you're wrong, Your Honor, that it cannot come in this format with these findings by this judge as to the evidence presented to him at the time of the hearing.
You're down to about 1 minute if you want to preserve some rebuttal, Mr. Earl.
Yes, Your Honor, I will preserve
Thank you,
that.
counsel.
Thank you.
Mr. Deutschman.
Good afternoon, and may it please the Court. My name is Fred Deutschman. I represent the claimant, the appellee in this case. This case, I think, really boils down to whether or not the record on this case contains unrebutted, uncontroverted, and stipulated facts do they rise to competent substantial evidence that the claimant presented her burden of proof to establish a prima facie case of permanent disability under our new act? If we look at what is clearly the uncontroverted and the stipulated facts, we know that this claimant had no prior problems with her right shoulder, with dizziness, with the blackout. She was physically capable of working for this employer since 2001. She had a compensable injury. It was accepted that her injury...
Let me ask you a question about the vocational aspect of the case. You agree that she was not directed to leave her job by a physician?
Correct.
She claimed that she could no, or she testified she could no longer do the work, therefore she left the job.
Yes, sir.
Now, does that have any effect on this case?
I think the fact that it went unrebutted. This happens quite frequently in workers' compensation cases where a claimant, an injured person, would have restrictions as she had during this period of time and says, I simply can't do the work that the employer is offering to me. The unrebutted evidence in this case was that she complained to the boss, they didn't do anything about it, and then she quit. And that went unrebutted. It could have been rebutted, and typically what you would see is somebody from the employer coming in and saying, those weren't the job duties that she's complaining of, or it really wasn't that hard. We did have work within the physical ability of her to perform. She said the desk was too high, I had to get up and down 50, 100 times a day, and it all went unrebutted. So that's the competent substantial evidence, but that's the facts in the records of this case that, again, unrebutted, uncontroverted.
What's the best evidence regarding the highest impairment rating that this woman had?
The highest impairment rating she had was 5%. And
I guess you can probably understand why the JCC was having some serious problems finding this woman permanently totally disabled with a 5% impairment.
Yes, sir.
So really it does boil down to what Judge Kahn has suggested, which is, does the statute say that what you presented is enough? Because obviously the JCC read the new statute that way and held his nose and said, I hate this result, but I don't have any choice.
Well, what the JCC was presented with was not only a 5% impairment rating that all of the doctors agreed to, and I think it is important to point out, these were all authorized treating physicians. None of these doctors was an independent medical examiner hired by the claimant. They were all authorized treating doctors provided by the employer carrier. Not only did she have a 5% impairment rating, but she also had restrictions that were placed on her that placed her at a sedentary level, and were actually significant restrictions in the context of this particular claimant.
The other problem, it seems to me, that you have is the JCC, in his findings, essentially said, look, I've had the opportunity to observe this woman, and I find it incredible that she's permanently, totally disabled from doing any work. But again, the way he read the statute, he felt he didn't have any choice.
To a certain extent, I agree with you, with all due respect. If he had found her to be incredible by the legal standard...
Well, I didn't say he found her to be incredible. I said he found the conclusion that she was incapable of doing any work to be incredible.
Troublesome.
Yeah, at the least.
Right. I understand that. But the question becomes, as to a legal standard...
Oh, and we all understand we don't write these statutes. We just do our best to make some sense out of what the legislature says.
Well, and to make sense of this case in the context of the question, is this a tough case? Was this a very difficult case for the judge? Certainly he wrote it in his order, and quite frankly, I was there trying this case, so I know the temperament of the court at the time. But faced with the uncontroverted, the unrebutted testimony of Ms. Panaccio, who was accepted as the expert, giving the testimony consistent with the statute that there is no work available for this person within the 50-mile radius. In fact, there's no job she could even apply for. The claimant carried her burden of proof in this case and presented the prima facie case. That then shifted the burden over to the employer carrier. there was no proof from the other side that this claimant was employable within the 50-mile radius. And again, as Judge Conant pointed out, I didn't write this law, this court didn't write this law, the legislature wrote this law. And there's quite a few things in the Workers' Compact that we know perhaps might result in harsh results sometimes. But that's that's for the legislature to make that decision when they write these laws. And this particular statute's been rewritten. I've been practicing this almost 30 years. I think probably 4 or 5 major revisions of this law, every time trying to get it right. Well, I don't know if they got it right this time, but I think in this particular case, the clear evidence is that the claimant carried her burden of proof, presented a prima facie case, tipped the scales in her favor with the uncontroverted evidence, and is entitled to the PT benefits, and the JCC should be affirmed on that issue as well as the TPD issue.
Thank you.
Thank you.
Mr. Rowland, you do have some rebuttal time.
Yes, Your Honor, really quick. It's going to be a plea. Try as I might, I believe, not only is this the first oral argument for the year, but this will be the first opportunity that we will have from this court to get some type of guidance as to what the expectations are on the permanent total. You know, we've been through the 93, or the 79 to the 93, and then the 94 to the 1 to the 03, and here we are starting all over again.
Well, I can tell you from one judge, and I don't know that there'll be another vote on this panel, but I can tell you from one judge, I just read the statute. It doesn't even mention permanent impairment. It says physical limitation, and then it imposes a vocational test on that. So how else can I read that but to say once you prove physical limitation, and once you put on vocational evidence of unemployability within 50 miles, the judge of compensation claims may accept the claimant as PTD? That's my question to you.
Your Honor, it is definitely an observation. If that's the finding, then we'll be back in the legislature again, I'm sure, real soon, because we're going to be inundated with permanent totals all over the place.
Well, see, the good news about all of this frequent rewriting of Chapter 440 is it keeps all of you folks in business. And it keeps us in business, too. So,
but we're still going to endeavor to do the right thing. Thank you, Your Honors.
Thank you very much. Thanks for coming to Tallahassee to argue the case, gentlemen and ladies.